the law of the state of arbitration, the applicable laws to the arbitral proceedings as well.
Thank you very much, okay.
Thanks. And just as a quick reminder, if I realize you will have some questions as well, and in order to maximize the time, the platform you just logged into, you can actually ask your question. So you'll see there are two tabs. One is the polls tab. One is the questions tab. So if you have a question you would want to ask, please feel free. Just be asking them on the questions tab, and we will put those questions to the panelists. So there's something I'd like to move. I'd like to move away from strategy for a little bit, if I may. And we'll come back to it because a lot of people are interested in it. But one thing I noticed when Deborah was reading the scenario was the fact that the arbitration clause seems not valid, to say the least. So we're dealing here with a pathological arbitration clause. So Mofe, maybe I can come to you next. In drafting the clause, even before a dispute arises, even before the contract is signed, what should a practitioner consider at that stage? Are there any guidelines that he or she can take into consideration in avoiding a clause that is pathological potentially?
Okay, thank you. I think the very first thing that anybody should have in mind when trying to put an arbitration clause together is whether the disputes, potential disputes, or if you're already, in the dispute scenario, is arbitrable. I think arbitrability should be the first consideration on your mind, because you don't want to put together a clause on an issue that you cannot arbitrate, and then you have to go to court to resolve it. For instance, if you have a tax issue, and there's some decisions on that already, Esso Petroleum and NNPC, Shell and FIRS, where there had been some agreements as to how tax was to be deducted and paid. Another thing I would want to point out as well is the arbitration clause should be taken as important as some of the other commercial and technical clauses in the agreement. Many times you find scenarios in which people have blindly copied clauses either off the internet or maybe from elsewhere. So I think the key lesson on that one is never blindly copy a clause from anywhere. But what I'll say, at minimum, a good clause should provide for recourse to arbitration, and it should have provision for the seat of arbitration, which is generally more important for international arbitrations, as that will usually also determine the law of the arbitration. It should provide for the number of arbitrators and the process for constituting a tribunal. For international arbitration, you could also add language and the applicable law as well. The appointment process is critical in putting together a clause. As we can see in the scenario that we have here, it says that it says that the arbitrators are to be appointed by the chairman of the Royal Institute of Chartered Arbitrators, London, Nigeria branch. As far as I know, that doesn't exist. So you then have an issue where you have a clause and you're eager to go into arbitration and you just don't have anything to do. You can't find anybody to appoint. In the scenario, I don't want to go into the area of challenges too much, but I saw that an emergency arbitrator was appointed by the Chartered Institute of Arbitrators. You have issues that could arise from there as well, because a different person from who the parties had initially agreed to appoint the arbitrators has then gone to do an appointment. What I'll also say in that respect is, generally, if you're unfamiliar with appointment authorities, arbitral institutions, it helps to do some fact-checking and personal research. Find out, okay, what are the institutes called? If you have the Chartered Institute or you have the Lagos Court of Arbitration, if you want an appointment from the head, what is the head called? Is he a chairman? Is he a president? Is he an executive secretary? Those things are important. because normally where disputes happen, people's eyes start to, look around the clause and see, okay, is there a precedent? No, there's no precedent. The executive secretary made the appointment. You have a problem. You may have to litigate that issue to be able to find a resolution. And then lastly, what I just want to chip in there is 3 things I think to avoid. Avoid a clause that is too specific, in the sense that you don't want to, for instance, say the dispute is to be referred to arbitration by a sole arbitrator, and you name the arbitrator, and for instance the person dies. What do? You run into problems. Or you say the arbitration is to be started and concluded within 21 days, and then you go and appoint somebody like Mrs. Roseviver and Chief Ojo. You're not going to catch them in 21 days. I know. So issues like that, and then the proceedings overhang, and then you have an issue. Is the award valid after being made 3 months from the date of the dispute? Then also don't have a clause that is too ambiguous. Shouldn't be too open-ended. For instance, no seats, no number of arbitrators, and you start grappling with issues. For instance, in the present Arbitration and Conciliation Act, the default number of arbitrators is 3. So you have a 5 million naira dispute, and then you have to appoint 3 people, and then you have to still pay your lawyers. What do? And then you should not have a clause that is inconsistent, which I have seen before, where in the body of the contract, generally, the words mediation, arbitration, courts are used basically interchangeably. So you cannot, at the end of it, kind of tell, do these people actually want arbitration? Which is the most critical element of it. Parties must actually want arbitration. But where they've said mediation, they've used courts, and then they've said arbitration, you can't decide at the end of the day. I think those would be my key points in terms of what a practitioner should consider when drafting or reviewing an arbitration clause.
Thank you, Mofe. While Mofe was talking, I couldn't help but recall several incidents I witnessed as general manager of the branch, where we had letters for appointments, but then we would have the president of the Chartered Institute of Arbitrators Nigeria branch. Now we use the chairman at the branch level, and we use the president at the global level. So I know there was a time when we went ahead to do the appointments, but they challenged it on the ground that one of the parties said that was not the intention, that they intended for the, so there's a parallel institute at the time that was bearing that same name, and they use presidents. So you have to be clear on such things. When you do the copy and paste thing, you have to be sure that the appointing authority is properly described as should be in any organization. So if it's the executive secretary that should make the appointment, then you refer to the executive secretary or the president or the registrar. So Mofe was quite right on that point. But Mofe, I'll quickly ask you, so is there a perfect arbitration clause?
I'm sure everybody wishes there was. That way you can now copy and paste. But I don't think that there is. I don't think that there is. But what I'll say is to bear in mind those minimum requirements that I have said every clause should contain. I think you need to have at least those, I think there are 4 necessities to have a workable clause that you can now spring off from. I have mentioned those already, so I won't go. But then I also want to say that clauses should be tailored to fit peculiar circumstances of the agreement. Like I had already said, you have a small dispute, you don't want to have 3 arbitrators on that. In fact, I had been in a scenario in which may ultimately be a good thing, where the amount in dispute was not so much, and then the parties had an agreement for 3 arbitrators, and then at the first meeting, the arbitrators were seated, lawyers were seated, and then they found out, okay, this was what the fees were, this was what was going to have to be paid. And then they said, okay, hang on, can we go outside and talk for a minute? And then they went outside and came back and said, you know what, we don't need this anymore. We've settled. So it may not always be that easy, but that's a scenario in which maybe a pathological clause has resulted in a happy ending. But it is good to bear those type of things in mind. I think it's very important. But as to whether or not you can have a universal clause that you can apply in every scenario, I think it will be dangerous to do so.
Thanks, Mufe. Mufe made a very interesting point. The 4 points that your arbitration clause should essentially meet. There was a gentleman called Frederick Eisman, I think his name was, that says, well, the 4 things that every arbitration clause should meet. It must have mandatory consequences for the parties. So you must go to arbitration, not may go to arbitration, right? It must exclude the court's intervention. So the arbitration is not discretionary, it's mandatory. It must give the arbitrators powers to decide the dispute, and it must put in place a framework that can lead to an enforceable award. So if you hit those 4 things, then your arbitration clause might not be perfect, there will still be challenges, but you will be well on the road to get in a very good clause. I'm noticing that while we were speaking, there's a very interesting question on Slido. If I could ask the Cogito team to please switch over to the Slido, please. And there's a question from Adeyemi, which says, let me just switch off this poll so everybody can see the question. And Ali, I'll ask you this question, so just be preparing yourself. So Adeyemi's question, let me go over, is, will subject matter know-how be a factor in appointment of an arbitrator in this scenario? So essentially, Adeyemi, I think, is asking, what criteria will you consider in selecting an arbitrator? So Ali.
Okay, thank you very much, Mr. Isaiah, for that question. Yes, we all know the well-established criteria, which are 1, independence, impartiality, integrity. But beyond that, the question he asked also is one of those criteria that need to be considered. That is to say, professional expertise. Now, it is a lot easier for you to engage an arbitrator, who has a professional expertise in a niche industry, because he wouldn't be grappling with trying to understand concepts and ideas. And the essence of arbitration is to actually save costs and to have the whole issues resolved within time. So one of the criteria, or one of those criteria that beyond impartiality, independence, integrity, is expertise or professional expertise, as it were. Thank you very much.
Thanks.
Yeah, I just wanted to chip in a little on this point as well. That one thing I always bear in mind when I'm doing matters is, I always say to myself and anybody who I work with, I think the person whose case is least complicated is more likely to win. And where somebody has a case that the arbitrator is struggling and is thinking, what do I do? You're more likely to have issues with getting that person on your side. So it is important to have somebody that you don't have to be teaching through the disputes process. Because at the end of the day, most people, the arbitrator has 2 people sitting before him, 1 on either side. Usually, they have a low level of trust at the beginning of the process. You don't want to trust what either person is saying first. So you don't want to teach somebody who doesn't trust you. You need to have somebody who, as you are taking him through the facts of your case, can follow and say, okay, I know what that is, I know what that is, I know what that is. Which is why, for instance, you're having construction disputes. They usually want to have maybe a QS on the panel or have an engineer or whatever. That's the main reason why. I think that will also apply in a scenario like this.
Okay. Maybe I should also add other criteria beyond that of the expertise. Other things, other criteria that they look out for in appointing arbitrators is also availability. We have a number of arbitrators that are quite busy, just like, is it a Bio made reference to Bio Ojo and our chair? Because we want to have them. They have a caseload. They have to have an arbitrator that has a manageable caseload. Because from the beginning of the year, you may have an arbitrator who has gotten his diary already full. So for him to call even for preliminary meeting could be an issue. And we're looking as to time. so that things could be done expeditiously. So also availability is also a key. Besides availability, another criteria also is to have somebody with people management skills. People management skills, because mostly in international arbitration, you tend to have people coming from different backgrounds, different cultures. Maybe a Nigerian appointing a Nigerian as an arbitrator. You have somebody coming in from, let's say, civil law jurisdiction. You have someone else coming. So you need somebody who actually will interact with these arbitrators, you know, smoothly and seamlessly. Besides that, you also need somebody who also has communication skills. How do I pass these information, disagree with these counsel, yet becoming firmly and persuasively? That is also key. Another criteria to look out for, but this is with bias to lawyers, is legal background, legal educational background. Why? Because each arbitrator is expected to give the rationale behind the rationale for arriving at an award. Because failure to give reasons or rationale for arriving at an award could be a ground even for setting it aside. So lawyers who have that formal training seem to actually have this easy. And also, in an arbitration, particularly international arbitration, you tend to have people from diverse legal cultures. We are coming from common law jurisdiction. Perhaps discoveries, exchange of documents is a lot easier. But you have people from civil who may not seem to appreciate this. And you have a lot of laws to interpret. Laws on the governing laws, statutes to interpret. When you have somebody who has a legal foundation or background, he will be able to actually add value to that thing.
Okay. So I'll just, while we go to the next, wait for the next intervention, invite Dr. Khrushchev Ekweme to join us on the panel discussion. Dr. Ekweme was in the Supreme Court earlier today, which explains his just arriving. You're very welcome, sir. And Dr. Ekweme is a partner with the firm of Olaniwo Ajayi. Okay, Kemi, I think I'll hand over to you to ask the next question.
Welcome, Dr. Ekweme, because we had a lot of questions on strategy, so we're glad you are here to dissect that. But I'll give you some time to catch your breath, and I'll just ask Aliyu, this question. So I'm wondering, should I look for an arbitrator that is sympathetic to my cause? Is that a quality to look out for in an arbitrator? Because where there is we have to decide, parties have to agree. So should I, in my search, should I start looking for someone that would tilt in my favor, is very favorable to whatever my course of action is?
Well, naturally, even when we speak of neutrality ordinarily, the neutrality comes in from the chair or the president. That is why, like I said, the neutrality comes in from the chair or the presiding arbitrator. You tend to find that parties seem to want to appoint arbitrators that are actually sympathetic to their case, meaning that they have somebody at the panel who will actually give them a listening ear. Somebody, if the counsel is pushing for perhaps discoveries, we should be able to say, okay, let's take a look at it, but not necessarily to compromise his independence. Yes, it is good to look out for somebody on the panel who is sympathetic to your case. But again, oftentimes when you tend to have so many of such people, or one person always being appointed on arbitral issues, arbitral references that you have, it could lead to questions of conflict, issues of conflict sometimes. Now, there is a particular case, that is the Halliburton case, the recent Halliburton case and Chubb. In that particular case, Halliburton had an issue, needed to have certain insurance claims from that Chubb. They appointed an arbitrator, and Chubb appointed an arbitrator. But the two could not agree. So the court had to appoint another arbitrator, who became the chair. Now that chair had become was actually an arbitrator that had been appointed at several occasions by CIArb. So while the arbitration proceedings was on, CIArb also appointed him on 2 other arbitration proceedings, separate from, which had no connection or link with the proceedings at hand. And that was not disclosed. Subsequently, Halliburton discovered that, and he was asked to actually explain. So he sought to resign. He said he will resign his appointments on those 2, considering what happens on this, but he refused. Eventually, he handed down an award, which actually his Halliburton's appointed arbitrator also concurred, but only raised the observation as regards his fairness. The matter went to the English Court of Appeal, and they looked at it. They said, no, he was actually not biased in any way. That several appointments, because it took actually the arbitral community by surprise. So what were we trying to say? Sometimes arbitral proceedings could be stalled by applications to actually remove, or applications to actually have the arbitrator recused by reason of either his non-suitability, because he has failed to disclose, and so on and so forth. So while it is good to have an arbitrator who is sympathetic, you must be careful so that issues of conflict of interest will not arise and scuttle the entire process. Thank you.
Thanks, Ali. That's a really, really important point. The one whether parties gravitate towards appointing an arbitrator that's sympathetic to their case. So, Dr. Kwame, welcome. Let me throw a question straight to you. Do you think that's actually a strategy consideration? Because naturally, you go into a case and your objective is to win, right? You don't file a claim to lose. So will the characteristics or the decision patterns of a particular arbitrator be part of the strategic considerations you consider in building your case?
Good afternoon, everyone. Apologies that I came late. I believe that the history of what an arbitrator has done in the past is a critical strategic consideration that one has to make in the appointment of arbitrator. But having said that, I do not agree that an arbitrator should be the counsel of the party appointing the arbitrator. People have that misconception that the arbitrator appointed by them should be in support of their case. But it's important that in choosing who your arbitrator should be, if you have what they call paper trail on the arbitrator, you know, articles that he has written in the past, if you have seen some of the judgments he has written in the past, you begin to know, you know, how this arbitrator will determine a particular issue. So the history of who the arbitrator is important. But you have to ensure also that the arbitrator that you're appointing, it's someone that will be fair and independent-minded. It's of critical importance. And again, it's someone of integrity. More often than not, you can think that you know where the arbitrator will go based on the history of the arbitrator. And the arbitrator, if it's someone that has no integrity, will go the other way. And again, it's also important in choosing your arbitrator to choose someone with the gravitas to convince other arbitrators on a particular issue. Because arbitrators ordinarily will meet to determine how to go, especially when you have a tripartite panel, as opposed to a sole arbitrator arrangement. So you need to make sure that the person you have appointed is very knowledgeable, because knowledge will prevail when rational people are reviewing legal issues. So if the person is very knowledgeable, the person is likely to be influential in the decision-making process. So in a nutshell, the history of the arbitrator is of critical importance. And again, you have to bear in mind, what kind of arbitrator is he? An arbitrator can be knowledgeable, but at the same time, that arbitrator is not efficient. So, and if you're a claimant and you have an inefficient arbitrator that will not quickly handle your cases, the process, it can hamper the arbitral process.
Thank you.
Yeah. Thank you, Dr. Ikweme. Okay, so Joke, now we've heard, quite a number of questions on how if the arbitrator tilts in a certain way, he can be challenged and all of that. So when would you say is the ideal time to challenge an arbitrator? Is it at the beginning? Is it right the moment you see the person's name listed, you can just go ahead and challenge the arbitrator?
I think most arbitral rules and arbitration laws are very clear about the timing for challenge of an arbitrator. For instance, the Arbitration and Conciliation Act provides that parties are free to decide on the procedure for challenge, but then goes on to say that where the parties don't decide on a procedure for challenge, the challenge must be raised within, say, 15 days of the appointment of the arbitrator, or within 15 days of your becoming aware of that issue in respect of which you want to raise the challenge. So there's typically a time frame for raising the challenge. And my own view is that any challenge should be raised timeously and within the time frame. Now, what's the danger of not raising a challenge to the appointment of an arbitrator timeously or within the time frame? The danger is that you may be seen as having waived your rights, to raise that issue. And that's also because Section 33 of the Arbitration Act, like many other legislation on arbitration, provide that, when you're aware of an issue under the Act or under the arbitration agreement, and you face to raise the objection, then you have more or less waived your rights to make the objection. So I would say, principally, if you're challenging an appointment of an arbitration or you're challenging an arbitrator's jurisdiction, the challenge must be raised timeously and in the course of the arbitration, so that you are not taken as having waived your right to raise the challenge. Another issue that would arise is when that challenge should be determined, but that's really a question that the arbitrator will decide.
Okay, thank you. I just wish to add a thing or two. This is because, particularly when it comes to issues of disclosure, at the onset, arbitrators are expected to disclose any conflict, if at all. But that duty does not end from the beginning. It ends even until the handing down of the award. So in the process of the arbitral proceedings, if one of the parties finds out something that will conflict the arbitrator that has not been disclosed, it could as well be raised. That is just in addition to that. So at that point, even though, let's say the IBA guidelines on conflicts of interest states that within 30 days, you are expected to actually raise those issues. But what if you were not aware of those issues from the onset, or the arbitrator did not disclose, but somehow down the line, in the midst of the proceedings, or somewhere down the line in the course of the proceedings, you got to discover that. Nothing stops you from raising, just like in the Halliburton case we just saw, actually. Midway, they raised those questions. Why did you receive appointments from the opponent? Thank you.
Thanks, Ali. I'm eager not to, for us on this side, to take over the entire conversation. I would like to bring you into the conversation as well. And I can see a lot of people are asking if we could repeat the 4 things which must be present in an arbitration clause. Essentially, it's the, you can call it the Eisman criteria, EISMANN. So the clause must produce mandatory consequences for the parties. That's the first one. It must exclude the court's participation. That's the second one. It must give the arbitrators the powers to decide the dispute. So they must be able to finally decide the dispute between the parties. And it must either provide or make reference to a set of rules that will give rise or that will lead to an enforceable award. So for instance, you'll see an arbitration clause that says any disputes to be decided in accordance with the Arbitration and Conciliation Act. Essentially, that decided in accordance with the ACA, that's providing the framework that leads to an enforceable award. Okay, so I hope that's taken care of that question. So, Kola, let me come to you with another question. Now, we always hear that the Evidence Act, which as litigation lawyers, all of us are familiar with, does not apply in arbitration, but that rules of evidence apply in arbitration. So just clarify, what's the difference, if any, between the Evidence Act, which doesn't apply, and rules of evidence, which apply?
Thank you very much. Let me first take one or two keywords from there. Evidence, rules of evidence. Now, what is evidence? Evidence is the facts which either prove or disprove the allegation, the cause of action there. Now, the rules of evidence is the process that allows you to either establish or to rebut those facts. Now, from jurisdiction to jurisdiction, these rules of evidence are usually codified. In Nigeria, we have the Evidence Act. But when we come to the arena of international arbitration, you cannot impose the codified rules of a particular jurisdiction upon the arbitration proceedings. But so, probably the parties can opt for either the IBA rules or one of the international rules. But what you see there is there are some key rules. For example, the right of equal treatment, which is also in the ACA, the opportunity of being heard. So whether they are codified or not, there are some fundamental rules that must be present in any arbitration proceedings. That if it's not there, one could properly say that there was no due process. It could give rise to legitimate excuse or allegation that I wasn't heard. So, for example, if you say the rules of evidence does not apply to arbitration, but the fundamental rules that relate to due process, the rules that relate to fair hearing, the rules that relate to equal treatment of the parties, were they observed, yes or no? If the answer is negative, then the whole arbitration falls away.
Okay, thank you. I think Dr. Kwame wanted to make a point as a follow-up.
Yeah, but my contribution is just to say that there are clear rules of evidence that you see arbitral tribunals apply without reference to the Evidence Act. So when you say that, when one says that the Evidence Act does not apply, it's simply saying you don't go to an arbitral tribunal and you are relying on the Evidence Act. But you can invoke rules that are codified in the Evidence Act. For instance, relevance governs admissibility. So it's a rule of evidence. You find it in the Evidence Act. And the arbitral tribunal will admit a document that is relevant. There is this concept of a without prejudice privilege. Evidence during settlement between the parties is a rule of evidence. So arbitral tribunals will apply it. Now there is also the hearsay, rule, the rule against hearsay. It's codified in the Evidence Act. The arbitral tribunals will not rely on hearsay. They will look at direct evidence in order to make sure that their decision is convincing. So it's important to understand evidence if you want to be a counsel in arbitration. However, it will be odd for you to expressly cite a provision of the Evidence Act, because the Evidence Act itself says that it does not apply to arbitration. So that's the point that I just want to make.
Thank you.
Sorry, Isaiah, can I just add this? When we say the Evidence Act does not apply to arbitration, the intendment is to strip away some over-formalistic rules, like, for example, proper custody, CTC, You know, all those admissibility issues. So the intention of excluding the Evidence Act is to ensure that those formalistic rules are not imported into arbitration. But the more fundamental rules, just like Doc said, the more fundamental rules relating to the ability of a party to present its case, the ability of a party to be heard, those rules must be observed and respected. Otherwise, any award made flouting those fundamental rules will be easily set aside.
So I think just to also mention, I think in terms of saying whether or not you can cite the Evidence Act, I think maybe the best way the way it should be looked at is not necessarily that you cannot cite the Evidence Act, but that the evidence, even though the Evidence Act does not apply in law, it provides guidance as to how to deal with evidence in certain scenarios. For instance, presumptions. The presumptions in section 167 of the Evidence Act. How to deal with facts when you have those type of issues coming up. So you may be able to cite a case, for instance, and say, you know, in XYZ case, this is how the court treated the issue of presumption of withholding evidence, for instance. The tribunal is not bound to follow that case, but it provides guidance as to what to do in scenarios where those type of issues are before the tribunal. Just as in your normal litigation proceedings, you say where you have issues on which you don't have previous Nigerian cases, you look at foreign cases. They are not binding authorities, but they give you guidance as to what to do where there is no previous, you know, precedent. Thank you.
Okay, so since I want to assume that we are not all lawyers here, so we would have some non-lawyers that don't even understand what is contained in the Evidence Act. My question now to Mr. Mayomi quickly is there a uniform standard? Is there something that, you know, for non-lawyers they can refer to as their own guidance? Can you just make reference if there's anything so we can take notes from this point? Thank you.
Absolutely. I think I've mentioned about two. There is the IBA rules on the taking of evidence in international arbitration. It's on the net. Anybody can download it. It's a simple guide to how to present your case before any arbitral tribunal. You don't have to be a lawyer. You don't have to argue over Section 84 that is this document, is it a computer-generated evidence? I mean, again, like the point I made earlier, the intendment of excluding the Evidence Act is to ensure that non-lawyers, if they so wish, can conduct arbitration without running into technical arguments that we have to go all the way to Supreme Court. So apart from the IBA rules, there's also the UNCITRAL rules, and even most of the institutional rules also provide concise guide notes as to how you can organize your arbitration proceedings. Thank you.
Thank you very much, Kola. I think I'd like to come back to what some questions that have been raised in the audience. So if we can go back to the Slido screen again, please. Cogito, can we go back to the Slido screen? So there are a lot of questions going towards how young practitioners can gain more experience. So for instance, there's a question here that says, how can new and young arbitrators with minimal or no experience get acquainted with a mentor in the field of practice and arbitration? And I think we can take that with two other questions, one by Kofoworola. Thank you. I apologize. I'll just say Kofo. While it's important to appoint an arbitrator who has professional expertise, would it matter if the arbitrator is not an expert? So again, it's going to that question of expertise. And Maton's question, how are young arbitrators supposed to get the much needed experience if these sessions are mostly closed and senior arbitrators aren't opening to training them? So a lot of the audience would like to know, as young practitioners, how can they get experience? So maybe, Dr. Ekweme, how did you gain experience? How did you come into a mentor before you became the doc?
Let me say this, quite frankly. I have mentors on other things, but I didn't have a mentor in arbitration. And I think it's important for young people to be self-starters. When I was in Germany in 2001, I was going online. I saw a summer program on international arbitration organized by the Humboldt Universität Berlin at the Tulane Law School, United States. Now, I wrote them that I wanted to participate. They sent me the fees. I wrote back to them again that I didn't have money. You know, that I would like to come. And I wrote a compelling application. And I attended. And that was how I started, you know, the study of arbitration. Then in 2002, again, by then I had saw, you know, about the Hague Academy of International Law. And why I'm saying this is so that, you know, young people know about that opportunity in the Netherlands, you know, offering 2 important courses on private international law and public international law. And luckily, in that year, there were courses on international investment arbitration, on the public international aspect, and then arbitration on the private international law. Now, when I joined Olaniyan Ajayi, shortly on my joining, I joined in 2008, late 2006, and I had an arbitration involving Mrs. Rodrigo. You know, a massive arbitration, massive, you know, involving the defunct Enron International, the Lagos State government, the federal government of Nigeria, and then the defunct PHCN. And that was how I started. And then, you see, what is remarkable is that I was a transactional lawyer in my firm. That time, I was in the specialized transaction practice group of my firm. Because it was arbitration, you know, I indicated interest. And they allowed me. And after doing that case, they now moved me to dispute resolution. You know, so, but that is not to say that you don't need mentors. There are people you will tag along with. I'm involved in an arbitration where one of the presiding arbitrators is here. And I saw that that presiding arbitrator came with someone that he or she wanted to gain experience on arbitration. So the person is having first-hand experience, you know, listening. So it's important that if you have a mentor who is an arbitrator or counsel, you talk to him. When you have a case, please, I would like to come along with you. Now you are having first-hand experience. Sometimes the clients will say no, you know, that it's confidential. We don't want to bring it. So don't feel offended. Now, you also, this kind of conference is also an opportunity. In this kind of conference, you try and open your mouth to speak, to ask questions. Sometimes you think that you don't have anything important to say, but you cannot judge yourself. Maybe what you will say will be the game changer here. And maybe what you will say will make somebody say, I will want to hire you, you know, and expose you. So you have to understand, you start yourself, or you tag along, you know, shadow an experienced arbitrator. I mean, look at this young man here. I mean, I also admire him, and I'm saying it because of what he has done in the field of arbitration. So that you're young does not mean that you cannot do something. We have been, Mrs. Vival and a lot of other people, we have been pushing, saying for diversity in international arbitration, to bring in young people, you know, to become arbitrators, become counsel in arbitrators. I mean, and I'm happy with your case study. You know, some of us that are old people, we don't understand, you know, some of these sophisticated transactions. So, I mean, the world is yours. You know, the world of when I thought it had ended with the Y generation. I didn't know that there is Z generation. And I got to learn about the Z generation in your case study. So when I saw Z generation, I said, what is the generation? So it is your world. Eh?
Thank you.
Thank you, Doctor. Thank you for that contribution. So we'll have to round up now. We would like to take just 2 questions from the audience. Questions, please, not comments. Questions. So if you have any question, could you just indicate? 1. Okay, we have just 1 question.
Remember what Dr. Kwame said about opening your mouth. There's another question there.
Good afternoon. I'm Latif. My question was actually echoed by Mr. Kola during the ICC conference some months ago, and I would like to throw it to the whole House. Why is it very difficult to find a dissenting award that the person dissenting is actually not nominated by the party? So basically you are like protesting on behalf of the person that nominated you. So he asked the question during ICC, and the panel, very eminent, they kept quiet. They were trying to nominate whether they could find an exception, and nobody, even the person that said he found one, couldn't give us the authority. So should we ban dissenting awards completely, because they almost always form the basis of a challenge? So you just read your dissenting and challenge. Everything he said, you just agree and challenge, that's all. So should we just make dissenting one-liners, I dissent? Thank you very much.
Thank you, Lati, for your question. So
let's take the other question.
There's one more person. Yeah. Oh, okay, great. Who is the other person?
I think there was another question towards the back. Yes. So.
My name is Delay Orieko. The question is, sometimes when we went to Kigali early in the year, somebody mentioned something about pupilages. I wonder, the question is, if the arbitrators now, or the institute, it's a good thing that the president of the CIArb is seated here, if they can cascade it down and find out if you guys can put heads together and see if we can run pupilages like NYSC, because I think that would probably spur some of us on. It doesn't have to be Nigeria. It could be Kenya, in any of the African countries. Even if it's going to be 6 weeks, if it's going to be 3 months, then everybody will then know that I actually want to face arbitration. And then you can create time in your diary and say, this is what we're going to do. I'm sure if you put up a poll now, out of these people seated here, that we should be over 50 that will say, I really want to learn this. If the opportunity is there, irrespective whether it's in or in Kenya, we would then be willing to go. It's something that I think the institution should try and consider for us. Thank you.
Okay, thank you for your comments. I would like to have Mr. Madumeri answer Latif's question, because he's the youngest member of the YMG that I know that has risen to the toppest echelon of the institute. So please, can you help answer Latif's question and respond to the comments on pupillage? Thank you.
Thank you very much, Madam Kemi. I think I want to restrict my answer to the first comment. And since the branch chair is here, I will allow her to answer the second question. Now, talking about dissenting opinions, is a very interesting aspect of arbitration practice. And my experience tells me that when you dissent, you are dissenting also in a way that preserves the integrity of the arbitral process and preserves the integrity of the members of the tribunal. Now, why did I say that? There is a principle they call the principle of collegiality in every arbitral tribunal. And what that tells you is that when you are dissenting, now the former president of this institute, incidentally, he taught me for a diploma program in Oxford. I was in a panel, an international arbitration panel. I dissented. But I dissented in a way that also respected his personality and respected his views. I didn't dissent writing my own dissenting opinion separately. If I had done that, that would have led to what you said in the basis of challenge. But, you know, some decisions we are taking in that panel on certain issues, they will just indicate that this issue was decided based on majority. That tells you that somebody had expressed a dissent on that issue. So my preference is always for people to dissent in a way that preserves the integrity of the members of the tribunal and preserve the process. Thank you very much.
Thank you, Mr. Madumeri. Is there anyone on the panel that would like to add anything to that? Okay. Latif, I hope you are satisfied. Thank you. Okay.
I think maybe just since it's a bit related to one of the other questions there, what I'll just say, I wouldn't go into pupillage or not, but what I'll just say is, I think the best thing to do, when Mrs. Roseviver spoke earlier, she said something which I think is very important, and I hope it didn't fly above many people's heads, is serve. It is the easiest way to do it, offer to serve. I have done that, even with Mrs. Roseviver, I have done that, you know, offered to do that for so long. That is the best way of endearing yourself to people that, you know, you believe can be instrumental in your development. Always offer to serve. 1, 2, I think it is important to try and invest in things like this. Always know, okay, good enough, this Chartered Institute usually sets out its calendar for the year. You can say, okay, I know that the conference is coming at the end of the year, maybe save up for it, because it gives you the opportunity of catching Mrs. Roseviver, catching a Chief Ojo, catching a Mr. Madmer in one room. You don't have to go to all their offices. You can catch them here. Don't allow them to go. Speak to them, see everything you want to do. They will remember you. They will see you again and say, oh, I know that you were here. You stick. And then you can kind of follow the process on like that. It may not bring money today, tomorrow, but trust me, that remembrance, that service that you have put is currency, and it is in the bank. Later in the future, you will be able to go and cash it. I think that's just...
Thank you, Mofe. Mofe is talking from experience, so I think we should take a cue from what he has said. Yeah. Mrs. Roseviver would like to add to this.
Thank you. On the question of pupillage, I don't exactly know what you mean by pupillage, but I underwent pupillage. And a lot of my colleagues that started our training some years ago, we all underwent pupillage. But if what you mean by pupillage is putting yourself out there, sacrificing for your sacrifice, then we do have pupillage. For my pupillage, I put aside buying shoes and bags, and I was always on the plane to London, because at that time, we were not as lucky as you were. There were very few well-trained arbitrators in Nigeria at that time. So we used to travel to London, and we got to know members of the institute. Tony Canham was a past president. He was very particularly nice to us Nigerians. And we'll go for preliminary meetings, you know, the kind of thing you have the opportunity to watch here. We'll go for preliminary meetings. One day, we'll go for hearing. We'll go for award writing skills. And that was how we were going all over the world. Not that we had the money. Don't get me wrong. Not that we had the money, but we were interested in our career. So we devoted... They don't accept it. They do, well, I'm telling you the truth. They dispute, but I'm telling you the truth. But I'm telling you the truth. I'm telling you how to get there. You know, and I can tell you the people we went with. I remember Mr. Belgore used to...
Silence, please. Silence, please.
I can tell you people, so when you see them, you can ask.
Silence, please.
Particularly Mr. Belgore, Mr. Busari and I, we were always on those same programs abroad. Chief Ojo too used to go. All of us, we'll get on the plane. We were always there because we wanted, and we did not have the benefits that you have. You don't have to get on the plane now. All you have to do, as has been said by Mofe, is get to know all these people. You catch them here. Oh, when do you have? I know a number of people that come to me. I like having them. I like seeing them. Even if they don't see me, my secretary knows them already. So I just say, Daniel, please help me put somebody's name. Please, Daniel, when I have a hearing, help me remember to put. That's all it takes. So there is pupillage, but not the kind of pupillage where anybody's going to fund. I didn't experience that. Anybody's going to fund me and say, Mrs. Roseviver, will go to Kenya or go to XYZ. I had to make the sacrifice, like a number of us too, in getting that required pupillage. And in fact, to get chartered arbitrator status, you had to fill your logbook. I don't know whether that's still the regime now. You had to fill your logbook and put in the trainings you've had, the order for directions you've written, you know, and then put it all there so that when you go for your interview, they look through your logbook and make sure you have the experience. So I don't know whether that answers your question. The question on pupillage, who was it that asked it? Does it answer your question, or there's another type of pupillage you are thinking of?
Thank you, Mrs. Rhodes Bible. Thank you. Like I said, we need to. Okay, caller would like to add to that. Okay.
Well, not precisely.
Okay. Well,
before caller makes his point, you know, our colleague who asked the question on pupillage asked us to poll the audience. So we'd like to do that. So let's go back to Slido. And based on what Mrs. Rhodes-Viver has said, sacrificing pupillage, not buying shoe pupillage. Do you then favor CIArb to introduce a pupillage system based on the criteria identified by Mrs. Rhodes-Viver? So you can simply answer yes or no. So just go on the system, and you know, everyone is already saying nobody says no.
Yes, 100%.
Yes, 100%. I think it's quite unanimous. The vote is going up and up and up. So, well, as Mr. Rhodes-Viver said, CIArb has a mentorship system. So I think it's a way to find how we can make it more known, the mentorship system, and make it more inclusive. So it's good to have your insights in this regard. Kemi, I think we should round up.
Yes, we need to round up so we can go into the mock arbitration session. I can assure you that you would enjoy that session. So stay back, relax. And all these questions, you would have answers to it. There's a networking cocktail after this. So if you want anybody to adopt you as a pupil, wait, make sure you see them after this session. Thank you very much.
Thank you.
And thank you to all our panelists. We really appreciate you for your time and effort. Thank you.
Thank you, sir.
Mrs. Oshukeye, please, can you help us with handing over the gifts to the panelists? Thank you.
We invite Mrs. Yejide Oshunke to come forward, please. Have you taken the photograph? No. Photographer, please. The photographer for the group photograph, please.
Please come and take us picture. There's no photographer.
Yes. Yeah.
Okay. Dear panelists and speakers, on behalf of the YMG, we say thank you for your participation in this session. Thank you so much.
We thank Mr. Mofe Tayo Oyetibo, Managing Partner of 12 Legal. Thank you to Mr. Ali Zubero, Principal Partner of Ali Zubero and Associates. Thank you to Olujoke Aliu, Partner Alukiano Yebode. Thank you to Dr. Khrushchev Ekweme, Partner Olaniwan Ajayi. And thank you to Kolawole Mayomi, partner SPA Ajibade & Co. Please, can we give them a round of applause? We also have gifts for our moderators, Isaiah and Kemi. We have... Okay, now we're going to... Okay. Can we just have a few minutes so we can set up the stage? Thank you.